Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we discuss a very, very important judgment. The case is Jaseela Shaji versus the Union of India. But why is it important? Because Justice B.R. Gavai, Justice Prashant Kumar Mishra, Justice K.V. Vishwanathan have spoken in detail about right to liberty in the backdrop of preventive detention, which is analyzing of Article 22. Of course, I will give you a brief gist. This is about a man who was detained under COFE POSA, which is the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. Obviously, his representation, which was to be sent, was not sent for a long time and he remained in jail. The matter landed up in Supreme Court. And what happened, of course, my panel will discuss. But the Supreme Court has stood for liberty. It is the right to liberty of a citizen. And this is very, very important for a just society. And that's why we discuss this judgment by Justice B.R. Gavai, Justice Prashant Mishra, and Justice K.V. Vishwanathan. Let me introduce to you my panel today. I would like to welcome Senior Advocate Arvind Nair. Good to see you and looking forward to an interesting insight from you today. We have with us, post his senior designation by the Supreme Court of India, Senior Advocate Nalin Kohli. Many congratulations to you on the gown, and happy to see you in your avatar as a senior, and looking forward to some interesting insights from you.
Thank you.
We have with us Advocate Ruchi Agnihotri. She would also speak on the subject which is analyzed in detail, including his judgment. We have with us Divyam Agarwal. He is a partner litigation, which is a dispute resolution practice, one of India's leading law firms, namely Jyoti Sagar Associates. Divyam joins us for the first time on Legally Speaking. So welcome, Divyam, to Legally Speaking, and looking forward to some interesting comments from you today.
Thank you for having me, Tarun.
Thank you. At the outset, let me request the person who just got the gown, Senior Advocate Nalin Kohli, to make his opening comment on Legally Speaking. Over to you, Mr. Kohli.
Thank you, Tarun, for those kind words, and good evening to everyone on the show and those who are watching it. I think, you summed it up right at the beginning. Ultimately, we hear it on a daily basis that bail is the rule. So therefore, in that context, there's been of late a spate of judgments that have come in the Honorable Supreme Court, which have examined and taken further this in terms of how long can you keep a person incarcerated. Now, obviously, that's in violation, or that is in conflict with Article 21, which is right to life and liberty. And then in Article 22, you have a set of protection for anyone who's arrested. So looking at the larger scheme, when you take it to preventive detention, which is a separate class by itself, which is not just the ordinary arrest under the CRPCOI as the new codes that we now have. In that case, in preventive detention, there's a little separate set of grounds that come into play. And those separate set of grounds means that you are exercising the right to keep somebody in custody. There is a certain mechanism under the statute by which the person can make a representation. And in this particular case, which is the latest judgment that you are looking at of Justice Gavai, Justice Prashant Mishra, and also Justice K.V. Vishwanathan, the issue here was related to smuggling, foreign exchange, habala. That's the basic facts. And in that factual context, the person was incarcerated. His representation was delayed. His representation, which he gave immediately to the jail authorities, was allegedly sent by ordinary post. And therefore, the question was whether it had reached the authorities. And then eventually the authorities said they hadn't got it. So therefore, his detention, continued for an elongated period on account of his representation not having reached the authorities. And this became one of the important issues before the court in terms of the violation of Article 22(5). That's the basic conspectus. And I think I won't take too much time. I'll let the other panelists join this, and then we'll build this debate further.
Okay, point very well taken. We will take a quick opening comment from Advocate Ruchi Agnihotri. Over to you, Ruchi.
Thank you for having me, Tarun, firstly, and hello, everyone. And yes, Nalin has picked it correctly, as did you. there is Article 21 of the Constitution of India, which guarantees to every individual their personal liberty and freedom. And we have a long list of judgments where the courts have only expanded on what comes under individual liberty and personal freedom, from everything, including right to privacy and such like, including the right to die, passive euthanasia, etc. So there is this huge catena of judgments that we have where right to life and personal liberty have been guaranteed. And then on the other hand, you have all these preventive detention laws, where in the garb of either sort of preventing terrorism or economic or affecting the economy of the country, authorities are given pretty wide-ranging powers. So therefore, the constitutional safeguards are there in the form of Article 22. But there was a period of time where Article 22, which lays down a very stepwise mechanism on how the rights of the détenu have to be protected, and what the rights have to, what the détenu should be given as rights, has been whittled down to some extent. Justice Gavai seems to be, because he's written the judgment, it's of course rendered by the three judges, but he's written the judgment. Justice Gavai is actually reaffirming what we have learned as lawyers. Exactly as Nalin said, bail is the rule, jail is the exception. Justice Krishna Iyer said that in 1977. That was reaffirmed in the Manish Sisodia judgment. Today, the judgment that we're discussing today actually only reaffirms the position that should be ordinarily understood and accepted. But he summarized the law. It's a very well written, very well analyzed, very concise and compact sort of a judgment. And certain material things have come across in that judgment. For example, what is relevant material basis which the subjective satisfaction of the detaining authority has been arrived at. In this case, some statement of a particular lady was not provided to him, and the court ultimately held that it was relevant and the detaining authority in fact relied upon it. The duties of the transmitting authorities, the jail authorities in this case, how it is a constitutional obligation and they cannot even delay. And Justice Gavai has actually gone on to say each day's delay matters. And in this case, there was a 9-month delay, really speaking, before the central government and the detaining authority actually had sight of the representations, which they should have had sight of within a couple of days. Also, the fact that in today's day and age, why was it sent through ordinary post? Why not an email? So there's this is a very fine balance between individual liberty, personal freedom, and preventive detention laws. He's not whittling down the preventive detention laws, but at the same time, there is a warning signal that has been given on how you should conduct yourself.
Thank you for that opening comment and explaining the judgment in brief. Now we go to somebody who feels for liberty very strongly. I've seen senior advocate Arvind Nair, even off camera, speaking on the subject of liberty, the issue of bails. And Mr. Nair, when you read this judgment, what thoughts crossed your mind? Also, could you share with us in your opening comment that what message the three judges, namely Justice B.R. Gavai, Justice Prashant Mishra, and Justice K.V. Vishwanathan, are trying to send by authoring this judgment? Over to you.
Thank you, Tarun, for having me, and thank you for framing those questions very articulately in your usual articulate manner. The thoughts that went through my mind when I read the judgment was actually, as has already been expounded, just to add to what my colleague Nalin said and also Ruchi said. The fact is that we know what is enshrined in Article 21. We also know what is enshrined in Article 22. 22.5, in fact, lays down the law that you have to supply grounds of arrest. But the question is it being done on the ground? Pun intended. I mean, is it on the ground? Do authorities actually follow what is enshrined in the Constitution as they should be, in form and in substance? What this judgment, I think, means for everyone is this is sort of it's a giant leap for personal liberty. And I'll tell you why I say it's a giant leap, because preventive detention is often affecting those people who may not be as privileged in society. Because perhaps, and I'm not, making a case out for any discrimination on the part of the state, not at all. I'm only saying that we have a very high percentage of the population who are below the poverty line, who are not very well educated, who are illiterate, semi-literate. They don't have recourse to legal advice as they should be. So they are not conscious of their rights. So if there is any whittling of liberties, they are not able to take any action as they should be, or as somebody who has recourse to a lawyer or better legal advice will be able to do. So this is actually a giant leap, because this has made it very clear. Nalin Bhai told us the facts. This, in fact, the judgment proceeds essentially on two issues. One is non-supply of material records. The second is delay in considering the representation. As Ruchi said, in this day and age, why not an email? Why not WhatsApp? If WhatsApp is good for every other form of communication, then why not this? Everybody uses WhatsApp. Everybody uses email. We see people glued to their phones and to their devices at all hours of the day. So that's one part. So it's a giant leap as far as I'm concerned. Second issue is about the message. Now, Nalin Bhai started by saying that we all know, and of course it's come down from judgments for at least the last 50 years, that bail is the rule and jail is the exception. But the fact is, when we write histories, or when academics write histories of judicial pronouncements, they usually follow trends. And let's not forget that of late the trend was, and there could be multiple reasons, I think to go into the reasons maybe beyond the scope of this particular show, but I think perhaps that trend that we were seeing was jail is the rule and bail is the exception. Whether it was the gravity of offenses, or it was better groundwork by the investigating agencies and the prosecution and other factors. But fortunately, the message that comes out is that we are back to the trend that bail is the rule and jail is the exception. And while you ask me about this judgment, let me just point out two other judgments pronounced by the same bench. In fact, different benches, but benches led by His Lordship Justice Gawai. One is, of course, they've been extensively reported. One is Manish Sisodia versus Directorate of Enforcement. This came out on 9th of August 24. The other is Prabir Purkayas versus State of Delhi. That came out on 15th of May 2024. Again, that trend that as far as personal liberty is concerned, the approach should be of zero tolerance. Both benches led by Justice Gawai. In fact, Manish Sisodia was Justice Gawai and Justice Vishwanathan. And Prabir Purkayas was Justice Gawai again and Justice Sandeep Mehta. So it's a giant leap, and it's brought us back. The messaging is, it's brought us back to the law as we knew it.
Thank you for that. Thank you for that opening comment and sharing some citations also on the same lines that you did. I'll go to Advocate Divyam Agarwal, partner litigation with Jyotisagar Associates. Divyam, you must be seeing a lot such matters because you are front-ending with the client, namely the accused, and so many cases you would have seen where businessmen are in jail waiting for bail. Of course, it's not so easy to get given how much our courts are clogged. Specifically, when you read this judgment by the three judges, what thoughts crossed your mind? Your opening comment.
Thanks, Tarun. Thanks. As I said, thanks for having me. You're absolutely right. In fact, I am currently handling a couple of assignments in Supreme Court where personal liberty is at stake. So my first reaction to this judgment, apart from the comments which my senior colleagues have made, was essentially with respect to Coffee Posa. We have seen that detaining authorities under Coffee Posa often take shelter of Section 5A, arguing that even if failure to provide some material vitiates certain grounds of the detention order would survive on basis of other grounds which, as per Section 5A, are severable. However, here the Honorable Court drew distinction between these grounds that are actually separate and severable, and ground which actually form part of one composite ground. Honorable Court noted that the chain of events which describe the detention order actually constituted a single ground, and the detaining authorities' failure to provide statements to the detainee meant that a crucial link in the chain was missing. In such a scenario, Honorable Court held that 5A, Section 5A of the COFEPOSA, not only would not apply, and the detention order would fall of the constitutional mandate under Article 22(5) of the Constitution. So for me, it was very relevant that the Honorable Court was willing to read into a statutory provision which is often misused by the authorities in order to justify technical issues which they have raised. That for me is actually very important. And I echo the sentiment that this is the giant leap. This is bringing us back to the same position that bail is the rule and the jail is an exception. So I echo that sentiment.
Point very well taken. I'll go to Senior Advocate Nalin Kohli. I want to ask him that what reasoning did the court rely on by sending his message? Also under the new Bharatiya Nyaya Sanhita gives us the rights of summons to be served electronically. In that case now, does everything, including even these representations that COFEPOSA accused in jail have to make, all that also becomes electronic, or is it only limited to summons in this case? Because if that becomes electronic, then this issue would have never arisen, because an email would have been it's not like your post that can get lost. Over to you, Mr. Kohli. You're not audible.
Yes, thank you. Let's pause for a minute. Let's pick up a few strands that have come up. And let's look at the larger picture, if you'll permit me. I think Arvind Bhai quoted and gave a very nice, it was a good point to bring in, that in the last 3 months, and if I look at it broadly in the last about 7-8 months, there have been a number of judgments on the issue of bail. Some of them related to political persons, but in general, looking at the law on bail and taking it further or reiterating the old principles in terms of bail being the right and jail being the exception. But let's look at the interplay for a minute. So you have a statute. A statute gives us a set of powers, lays down a procedure, lays down what are the exceptions, etc., etc. The power to arrest is a wide power, and that power exists with an investigating officer, mostly the police, in some cases a specialized agency, to undertake that arrest. Under the old code, it was 41. Now, the next is, the minute you've done arrest, there is the Constitution, obviously, in Part 3, in fundamental rights, places a set of guarantees that are inviolable, which includes the right to life and liberty. Now, from that perspective, you have a conflict coming up with liberty being curtailed, which is when the arrest comes in. Therefore, the procedure comes that you need to be before the court within 24 hours. And from there will flow the point, when does the charge sheet have to be filed? Which again, there's that 60-day, 90-day, the question of default bail, anticipatory bail, regular bail, things like that. This is the scheme within which this interplay happens. Now, in essentially crime being an act against society, let's also start at a position that economic offenses, and in this particular case, it will have the element of economic offense, the intelligence may and the entire modus operandi may be beyond the normal. So that's when the preventive detention use comes in under specific acts. They're not one, several acts. And therefore it is, let's stop the crime and do it. The problem starts where in some acts, it would be reason to believe, recording the reasons in writing, a prescribed section, as in this case, Divyam was pointing out, Section 5. You need to follow that procedure. And when that gap comes, the courts step in. And I think when the courts step in, as Justice Gawai has in this 3-judge bench judgment, is to, quite correctly, read into that or explain the applicability of the section in a wider sense. That if you have multiple grounds, the law is clear that they are not fatal. First, all material need not be given, because the material may be very onerous in the amount and the quantum. So all material need not be given. The relevant material is the critical factor. The second is the grounds. In this particular case, it was a single ground which was looked into in great detail. It wasn't a clash or an interplay between different grounds. So I think, to sum it up, what my other colleagues have also put, is that this is about setting in place what is the well-known fact and what the Supreme Court has been saying through the last 40, 50, 60 years. And Justice Gawai has been expanding it over the last few months and reading it clearly again, repeatedly, that bail is the rule. That's one part. The second part is it creates an onus now on the investigative authorities or the statutory authorities that they need to comply in letter and spirit with how the statute prescribes something when you are crossing the line and basically curtailing one's liberty through an arrest.
Thank you, and point well taken. Recently, we did a show on the Bharatiya Nyaya Sahita where this provision where email could be used to deliver summons. I think from now on, if that is possible, then the reverse would also be possible, where people who have been detained could also make their representations via email. It remains to be seen whether it happens, but at least the new laws provide us that right. I'll go to Advocate Ruchi Agnihotri. One of the arguments made in court was that the person detained was not provided the documents relied upon by the police for getting him detained, and his rights were violated. Could you reflect on that point and why this message now goes strongly from the Supreme Court that, at least don't deny someone detained because otherwise he can't make his representation? Over to you, Ruchi.
So to take it forward from what Nalin has just said, the Constitution under Article 22, what does Article 21 say? Article 21 says no one will be deprived of their life and personal liberty except according to the procedure established by law. Article 22 expounds on what could be the possible procedure established by law where you can, as an authority, sort of deprive someone of their personal liberty. One of the things guaranteed under Article 22, it's a constitutionally guaranteed right, is that you must be given all the materials basis which you have been arrested or preventively detained. 1. 2, you must be given an opportunity to make an effective representation. So your question actually stems from what you mean by an effective representation. When you say effective representation, you are also talking about what are the grounds, materials that the authority the detaining authority in this case, the corporate joint secretary in the corporate cosa, who, what did he or she rely upon before arriving at the so-called subjective satisfaction that this person, the accused, the detainee, can be detained, right? Now, the court also distinguishes, to take Vivian's point forward, the court not only distinguishes between what could be severable and what could not be severable, the court also distinguishes on, what are the, whether it's something in a passing reference in the order of the detaining authority, or is it material to the arrival of that subjective satisfaction. Now, in this particular case, there was some lady called Preeta Pradeep or something. She had made certain statements and her statements were recorded. And the respondents took a plea before Justice Gawai and Justice Mishra and Justice Vishwanathan that he knew that her statement had been recorded, and because they were obviously doing business together, he would know what she's saying, and therefore it's not material that he was not provided with her statements. But the court, when they actually reviewed the detaining authority's order, which allegedly had 12 grounds, but actually only one ground relying upon several materials to arrive at that subjective satisfaction, realized that this particular lady's statement was critical and very relevant to the arrival of that subjective satisfaction. And therefore, the court said that the detainee should have been provided with that because it is not a passing reference in that order. So in that context, the question of what materials are relevant, it's what is relied upon by the authority to arrive at that subjective satisfaction, saying, yes, this person can be detained, because within 3 months, you have to arrive at that, whether, the person can be continued to be detained.
Point well taken. And I'll go to Senior Advocate Arvind Nair on this specific point that the person detained was not provided with the documents basis which he was detained. It in a sense hinders defense. How is So what message the court is trying to now send, and do you think this will have a pan-India impact? Because in other cases also, if people detained under Coffee-Posa are not given documents relied upon by the prosecution, then obviously the defense is hampered. Over to you, Mr. Nair.
Tarun, I must answer that with a sort of a layered answer. Let me point out. Now, providing documents and grounds of arrest is very important. We know that that's not done. And that's not often done by the authorities. The authorities have been pulled up. This judgment will send out the message that there is going to be a zero tolerance sort of approach. Now, why has this law developed like this? It all starts from the first judgment, which began this jurisprudence. That's Shibban Lal versus State of Uttar Pradesh. That's a 1954 judgment, where the Honorable Supreme Court said that courts are not competent to inquire into the veracity of facts that form the basis for detention. Two, where they said we have a limited role for judicial intervention in preventive detention cases. Now, what happens is, with due respect, the kind of density that we have and the kind of population we have and the kind of ratio that we have to understand that the authorities also work under a lot of pressure. Now, with many courts feeling that let's not sort of dive deep into the factual issues, and also to not examine the correctness of the arrest, the authorities have also, we have seen in some cases, of course, as I said earlier, there are cases where the authorities have done a great job. Investigative agencies are doing very well. They're doing far better than they've ever done in the past. But there is a tendency sometimes to say that, all right, we will just pay lip service to this need. We need not actually do this. Or as Nalinji said, we need not follow it in letter and spirit. So that message has gone that you have to follow it in letter and spirit. That's one. The other two judgments that I cited, perhaps why I said, because it's a trend. As I said, judicial history is written on the basis of trends. Now, in those two judgments, the emphasis has been on factors which determine personal liberty. That's speedy trial, one. Two is prolonged period of incarceration. Three is supply of grounds. Fourth is, in Prabir Purkayas, the Supreme Court says that the remand application was not given. Now, there has been a trend, as Divyam said earlier, to read down a provision. What we have seen actually that transpires often in courts is that once you challenge the legality of the arrest, the courts will often turn around and say that, look, the arrest is already done, especially at the trial court level. So it becomes kind of fait accompli. They say, all right, the arrest is already done. Let us not examine the correctness. It doesn't matter, this ground or that ground will work. So to be able to again emphasize that, look, if you don't supply grounds of arrest, if you don't actually follow everything down to the T, and I don't want to read, because we are not in a courtroom, I don't want to quote from paragraphs, but paragraph 58, where the Honorable Supreme Court in this judgment actually pulls up the authorities, says that you've got to get your act together. So that's one point of the answer, that as all my esteemed co-panelists have said, there is a reiteration of everything that we knew, that is there in the Constitution of India, that is there in several judgments. So there is this much needed reiteration, and it's happened in more than one pronouncement. The other part is, look at the pan-India message. Since you spoke about the pan-India message, I am reminded of something. It's again something not directly connected to this show, but in the last 2 or 3 days, there has been this news report of a leading industrialist having been scammed. Now, if you read those news reports, that has happened because of something known as digital arrest. I mean, look at the creativity of the perpetrators. And where does that come from? That comes from that overwhelming fear which a leading citizen, we are not talking of somebody who doesn't have recourse to legal advice. This is somebody who could have dialed the phone, and many top lawyers of the country, friends like Divyam, would have picked up his call in an instant. But he was so afraid that he didn't even consult anybody. He scammed of crores of rupees. And I actually spent some time reading about what is digital arrest. So you're supposed to be on a video call, and you're not supposed to go out of the frame. And so this fear is possibly because of the feeling in a common citizen that, look, once there is an arrest, it's going to take ages to come out. In the particular case at hand, the present case, which you're talking about, the arrest happened on 2nd of September 2023. The much needed intervention from our Honorable Supreme Court is dated 12th of September 24. So it's for an average person on the street, that's the kind of fear that grips them. And that's so that messaging, that pan-India message that, look, due process of law will be followed, authorities will be pulled up. In Manish Sisodia, what was the issue? The pleading, I'm only going by the pleading, I'm not going on any other factors, as I said earlier. One of the arguments was that the person in question was delaying the trial. The Honorable Supreme Court says there are 70,000 documents. Now, again, the question is, how do you digitize this? How do you make it more efficient? Just to come to something which Ruchi said earlier, in her opening comments, Ruchi used the word balanced approach. And I think my own view is, of course, none of us is qualified enough or experienced enough to give any sort of certificate to the honorable judges. But I was reading, and I found in his Lordship Justice Gawai's extensive experience as a counsel, he spent a lot of time as a prosecutor. And I think that's possibly a reason why we are seeing this trend of judgments. Because having spent time as a prosecutor, you sometimes perhaps are able to anticipate what is going to be argued by the prosecution, and you know whether actual protection that is enshrined in so many of our laws has been followed, whether all those articles have been followed, whether grounds of arrest have been supplied or not. I think that's got to do something with it, and I think that's where the balance comes from.
Thank you for explaining it in a beautiful way. I'll go to Divyam Agarwal, partner with Jyoti Sagar Associates. Divyam, non-supply of documents relied upon for arresting a person. You see that happens often because you deal with many such cases, or do you think this is a one-off that happened in this Coffee Posa matter and the court was pretty angry about it?
So this is a norm, I would say. I'm actually facing a case right now wherein, and taking a cue from what Mr. Nayyar also mentioned, in my case, there are 19,000 documents that have been supplied to us. They have just been dumped on our desk, and we have been told to find out which document is applicable how. And we are still right now, imagine 19,000 documents, I'm not talking about pages here. So it is a very, very common practice, and it keeps happening. But I think these kind of judgments are absolutely required to deter all these sharp practices, so to say. And I must say that this judgment really underscores a fundamental rule of criminal jurisprudence, which actually flows out from Article 22(5), that any person detained by any authority must be provided with the materials based on which detention is made. This ensures that the detention is not arbitrary or capricious. In fact, I like to cite two judgments, and I'll keep it short. One is the Constitution Bench decision, and that too of 1953 of Justice Patanjali Shastri, Chief Justice Patanjali Shastri, in Ramkrishnan Bhardwaj versus State of Delhi, where he refers, and I quote, "Preventive detention is a serious invasion of personal liberty, and such meager safeguards as the Constitution has provided against the improper exercise of the power must be zealously watched and enforced by the court." In fact, Justice Krishna Iyer in Bhutnath Mehte versus State of West Bengal, he said that there should be a meaningfully comprehensive furnishing of essential particulars so that the executive agencies may be rigorously held to the standards set by the courts and the Constitution under Article 22(5). So yes, I absolutely echo that there are misuse which is happening, and this is what I underscored when I said that Coffee Posa Section 5A has been at number of times it has been used by the authorities to suggest that we can give you, they do cherry picking and they decide what to give and what not to give, and then they take the defense under Section 5A. The court, in fact, the Supreme Court said that while we agree that you don't need to give everything, but what makes the plinth of your case, what makes the real essence of the case, you must provide that. And that's how a fair investigation should be.
Thank you for your comment. I would like to, in a sense, sum up this discussion where all our panelists laid down the grounds on which, in a sense, the court has come down heavily on the prosecution. First, on their failure to provide documents relied upon for arresting this accused. Secondly, also delay in sending his representation, for which it took 9 months to get a reply. But a strong message has been sent by the three judges via this judgment, namely Justice Bhushan Gawai, Justice Prashant Mishra, and Justice K.V. Vishwanathan. Why we do such shows is to celebrate when our Supreme Court stands by liberty. This message, in a sense, also provides hope to a lot of investors who put money in India, because disputes may happen, people may get in cases, but the court is there to stand by you. This message should go out to everybody that the Supreme Court stands by you, it hears you, and justice will be done. And of course, this judgment will be cited now when documents are not provided or when there is delay in representation. That's why we take it up. And I would like to thank Senior Advocate Nalin Kohli, Senior Advocate Arvind Nair, Advocate Ruchi Agnihotri, Divyam Agarwal, Partner, Litigation, Dispute, Resolution Practice, Jyoti Sagar Associates, that you all made time. You came and spoke on this very important judgment. And of course, a lot of people have a lot to take away from this judgment. Thank you, viewers, for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.